Good morning. It is December 11th, 2024 at 9:30 a.m. and this is a deliberation of the Baltimore County Board of Appeals in case number 21-184 SPH on the issue of a remand of an unreported decision of the Appellate Court of Maryland in the matter of how many papers? The Rosebank of Iris Maggio et al. And the Rosebank Avenue Group LLC, 8209 Rosebank Avenue in the 15th election district of Baltimore County, the 7th councilmanic district. There was an order issued by this board that was appealed to the appellate court that has remanded the matter to us because we did not provide a reasoned analysis or explanation such that the court could further determine the sufficiency of the facts and conclusions of law. This was a case where there was a residential property owned by the Maggios that adjoined an industrial property owned by the Rosebank Avenue Group. The Maggios asserted that there was a service garage operating at the property at 8209 Rosebank Avenue. We found that there was no such service garage functioning there. The court cited a prior case decided by the board, CBA 20-021, in the matter of Tatiana Prasol and Vladimir Besser, where a different panel of the board found that there was a service garage despite the fact that there was no remuneration involved. We found that the lack of remuneration was determinative of the fact that there was no service garage. In so doing, and once again, too many papers, we look to the definition in the zoning regulations, which includes the language, the requiring of remuneration, and noted that it was not very artfully written. But to further explain the reasoning as I see it, is that it is not appropriate for us to ignore a word, any word or all words in the definition, that was an intentional act of the county council, and to ignore it would be contrary to what the council intended. And if the county council wanted it to say whether or not there was remuneration, they would have done so. And I think it would be overreaching on our part to simply adopt a position that that language is surplusage and should be ignored. So that's my thinking on that piece of the decision. Also, to distinguish it from the 2021 case, that case factually was very different. Both properties involved were zoned residentially. This property is zoned industrially. The neighbors, the Maggios, moved in next to an existing operating industrially zoned property. I think the expectation, a reasonable expectation when you move next to an industrial property is that there's going to be activity that's permitted within the zone. Some of it might not be totally compatible with a residential use, but it was pre-existing and permitted uses, which is, I think, is a basis for finding that use both reasonable and within the definition set forth in the zoning regulations. That's my thinking. So I would ask you if you could further, if you have further exposition of what your thinking was in reaching the decision. I don't think Sharon sat on that hearing.
I did.
You did.
I did not.
One of, yeah.
So, because I sat, if it's okay for me to add some more context to what you just said, Madam Chair. In the deliberation, and I mean, there was extensive discussion around whether or not there was evidence of remuneration. I mean, we all agreed that that was required in the definition for a service garage. And so we talked about whether or not there was any evidence provided to show that the activity was beyond a hobby and there was any consideration that was given for the work that was done on the cars. And I even mentioned that I was a little challenged by that, but there was no evidence to contradict the testimony of the Rosebank operation and what they were doing on the property. We even asked questions regarding the red dye, which the court referenced, and we were given a response that the red dye was used for heating. There were no photos to show that there were any, exchanges of any type of money or other type of consideration. We talked about whether or not they could have been bartering and not used money to exchange for these services. And none of that was actually entered into evidence at all for us to consider. So I agree with you that it's very distinguishable from the Praisal Bezer case. And the fact that, as you mentioned, they were residential properties, this had industrial with other related businesses that were so in close proximity to this property that there was, of course, expected activity, high volume activity on these properties. And so, as you mentioned, that should have been the expectation. I think what also was distinguishable is that in the unreported opinion, the court said that there was testimony in the Parasol case in which there was also it was an evidentiary record that was established that one of the parties stored and repaired motor vehicles on the property, and that there was a log that existed. And in that log, there was a notation that one of the vehicles were for sale. I mean, that was entered into evidence in that other case. And so they had something to give some type of, I would guess, like indicia of activity that was happening on a property that would have been a representative of remuneration. And we didn't have any of that presented in this case. So, I mean, I feel that we considered it, and maybe we could have written it with more detail to state what we all considered to reach the conclusion. But if there's no evidence, there's no evidence, so there's nothing for us to include in detail for writing the opinion.
Mr. Lauer?
Yes, thank you, Madam Chair. Excuse me. I believe Mr. Sampson was on the original panel. I have, excuse me, done my best to catch up with everything, having read the Court of Appeals opinion, the Circuit Court opinion, of course, the board opinion, and viewed the public deliberation and other matters. If I were on the original panel, I believe I would have agreed with you all in terms of your finding in the matter. I didn't find that in looking through things that there was substantial or credible evidence that there was a service garage there. To the contrary, as was stated, there was not any evidence really of that service garage. And to the contrary, I think that the board found credible the testimony of Rosebank regarding their not being a service garage, i.e. no payments, no sales, etc. I think, Chair Dopkins, when you're in the public deliberation on the matter, you also mentioned, I jotted down here, that there were city and state inspections. And I don't know that that was in the opinion. I'd have to reread it again. And I think the city and state inspections of the matter also, in my opinion, would weigh, if they're not finding it also, and it's been inspected, then that's more evidence that it isn't a service garage, if you will. I think the case that you're mentioning in terms of the BR, I would just say as to that, it's much more compatible hobby in an ML district than it is in a BR district. If you call it a hobby or whatever, I think the reference was. A couple other things. I don't know that the board wants to go down the road, and I wouldn't want to go down the road of saying, if a friend comes over and I help that friend repair, do something on their car without remuneration or sale, hiring someone to work or whatever, that's a service garage. That seems like a kind of slippery slope if we start going down it, to me. I think the burden was on the appellants to show that by a preponderance of the evidence that there was a service garage there, and I don't think they showed that. I think to the contrary, it showed that there wasn't a service garage there. So that was kind of my take in reviewing all of this and seeing what the board had done and going through the record as best I could. So that's my take on the matter.
The other point I think is worth making, which the other case, the Praisall and Besser case, creates, it was the exact situation that the county has strived to avoid, where people do these things on residential property. They want them to have them occurring not on residential property, but on appropriately zoned property. So what was going on at Rosebank was a solution to the problem that was identified in the other case, that it was not occurring on somebody's backyard.
Yeah.
And I found it ironic that the court would point to that case when the reality in Baltimore County is when these situations come up on residential property, the solution is to remove the activity from the residential property and relocate it to a property that is zoned for that hobby, that kind of activity.
Right.
And I think for all those reasons, we can support our decision, and so we'll issue an amended, I guess, decision in response, or a decision on remand to further elaborate on our reasoning, because there were plenty of reasons to find what we found, not the least of which was that the county, in inspecting, found no such inappropriate activity. So I think we're in agreement.
Yes, I agree.
Yes.
Okay,
All right.
thank you very much. I'm
Thank you,
going
Madam
to
Chair.
go off
you.
the record. I wish everyone a happy holiday and hope to see you soon.
Same to you.
Thank you.
And we are off the record.